Ryan, if you would introduce yourself and then walk right on into the talk, that would be great.
Sure. My name is Ryan Nash. I'm the COO at Gust. I've been with Gust for quite a while now, almost 8 or 9 years in various roles. I have an engineering background, but I sort of drifted over into people and operations management. And at Gust, we've done a ton with startups, starting up, acquiring, spinning out, building tools to help them out, helping angel investors, helping accelerators. But the last maybe 4 or 5 years, our focus and my focus in particular, as well as Peter Swan, who's the CEO of the team that actually runs this, is something called Gust Launch, which is a SaaS platform to try and automate and take away all the back office mistake-prone busy work that it takes to run a corporation, so that founders can focus on what they do best. And Pete might join us a little bit. He's tied up in some other stuff, but he might show up in 15 to 20 minutes to correct everything I say. And make fun of my broad generalizations. And I guess we'll get started. So let me do the screen share dance. Can everybody tell me if they can see this?
Yeah, looks good.
All right, let me drag my Zoom people over so I can see you guys. And also I want to thank John for setting this up. And it sounds like we have a really great group, the half relevant, and we'd love to show you what we have. So this talk is all about the early days, startup formation, equity, early legal, and kind of the pros and cons of using the platform or mostly pros. The biggest thing here, and a theme that I'm going to cover over and over, is most of these things aren't the end of the world if you mess them up, but you can end up spending handsome amounts of fees if you kind of just sort of Wild West it in the early days. Our specialty is Delaware CCorp. Sounds like we already have a couple in the audience, but I will speak to LLCs a little bit. Most fun part about this talk is it is almost Halloween. So John, talking to me earlier in the week, said maybe we should spooky this up a little bit. So this is the spooky edition of startup formation, equity, and early legal. There are pictures of zombies, but they're cartoon zombies if anybody is scared of zombies. But the biggest thing is early corporate mistakes. And I mean a corporate mistake is like forming the wrong entity, not doing certain, esoteric little things with stock grants and whatnot. It's easy to avoid doing this stuff or addressing it in the early days, one at a time. It's like, we missed that window. Maybe it won't be too bad. But if you don't take care of them properly, it's not just enough to avoid things. It's like doing the right thing. It can build up over time and really overwhelm your business to negative effects, usually costing lots and lots of time and money, mostly going to lawyers and accountants to clean up the stuff that you did or did incorrectly or didn't do. So things have changed quite a bit in the last 5 or 6 years. There are legal tech SaaS platforms out there that can help you keep on track, avoid those mistakes, and honestly better run your business overall. But in order to kind of understand that, we're going to go walk through what I'm going to call the haunted house of early formation gotchas that trip founders up quite a bit. This is mostly oriented to tech companies, but tech-oriented startups who plan on getting investment from the outside, granting stock to shareholders or something similar to that. Oh, and John, do you want to pause for Q&A in between or save it until the end?
It's entirely up to you. However, it'll flow best for you.
Sure. Some of these concepts do get very interrelated. So if anybody wants to ask a question or put something in the chat, I can address it midstream, or I'll save it to the end if it's a little more complicated. I guess we'll just use the chat for that. So I've got that open on my other screen. All right, so the first up is even what is legal entity? A couple of you have said like, I'm really early stage, we haven't really set anything up yet. Why would you want to do one in general? So there's 3 core reasons. The first one is usually the most important and the most pressing to do it earlier than most people think. And that's limiting your personal liability. Specifically gearing more towards US-based and similar in Canada, but businesses do not flow their debts onto the people who work in the businesses. So you want to set up an entity that is going to take on liability for the business that you're going to conduct. In America, you can sue anybody for any reason, and you don't want that taking away your house or damaging you personally if things just don't go well with your business venture. A second reason is really to just put value into something that collects and owns the assets and the IP that is created when you're doing a project. Generally, if you're not employed and you're just producing something, by default, you kind of own that thing. But if you're going to try to convince somebody that a company is worth money, you want to be sure that the company has an official audit record of the stuff that is associated with the business venture. And a more interesting one, and where some of these, laws and stuff like that actually make some elegant sense, is corporations and organizations are rules and systems of collaboration to actually help enable building and capturing value in something bigger. If you work on a side project, do you sell the projects? Like, no, you usually sell a company or an organization. And I'll get Alex real quick. A Canadian controlled private company corporation as a foreign Delaware CCorp. Is that a thing, or do we need a Canadian subsidiary branch? So this is, I've generalized this a little bit. Relationships between legal entities and organizations are very common. What type of organization you have determines what sort of relationship you can set up. So things like a C corporation, a Delaware C corporation, they have very structured rules in terms of what ownership is. It's split into shares. Shares have votes and things like that. It becomes very easy. You can give shares to an LLC or a foreign entity or firm, and you know exactly kind of what ownership that means. When it comes to other kinds of entities, LLCs, limited partnerships, things outside in other countries, each of those has their own variant of what they would need to be associated with that. So that might, depending on the entity, you might need custom legal work to get the right agreements to mirror what you're kind of talking about. Does that help, Alex, or do you want to add more clarity there?
No, that's good.
Cool. So those are the three reasons I've introduced ghost stories. Thank you for John for thinking this up throughout this presentation, which is just fictional examples of trying to do a thing and how it can go wrong and what the downsides are of it. So in this particular thing, we have a founder named Juan. They're working on a side project. Nobody else is involved, so they're not really thinking about making an entity, but things are kind of going cool, and they actually raise some money from just people they know. These aren't professional angel investors, so they're not really doing diligence, but they like what's going on. So he just gets checks and uses it to try to grow the business, spends it on some things, but it doesn't work out, as some ideas don't. And somehow the people who gave that money over are spurned. There was a miscommunication somewhere. Most things were email. There's not a lot of contracts, but they sue Juan, and they say like, hey, we want that money back. You spent all our money and there's no thing here. Because there's no entity, the only person to sue is Juan. And rather than a company with no assets, you can see over on the right, you don't want, sometimes companies work out, but you don't want you to not work out from your venture status or attempt. So now that we know why you would want one, when is the right time to form it, which might be relevant to some people here are kind of right on that sedge. We think, again, there's three different things. One, there's a forcing factor of when you really have to. There's certain things you just can't do as an individual. Like if you want to get an app in an app store, they're going to ask for what's called a DUNS number, a Dun and Bradstreet number. In order to get one of those, you need to have an EIN. EINs are a federal tax ID. They'll apply to both LLCs and C-Corps or most things. EINs are also required to get a bank account. A lot of times investment. So if somebody, a grant, an accelerator is about to get into, you give you a small kickoff. They're not going to write a check to your personal bank account unless they don't really know what they're doing. So they'll look for a corporate bank account. So those are the forcing factors you pretty much have to. We've seen many customers end up on our doorstep after winning a business plan competition with a check that somebody wants to write to them, being like, I can't get this anywhere. It's like, yeah, get a company set up. Outside of the forcing factors, the second thing is when you can afford to. In Juan's case, as we were talking about before, if money isn't a pushing object, it's just safer to overall put something into an entity. The costs of running an entity for most states are in the low hundreds of years and a couple hundred to set up. So if you're doing anything meaningfully and somewhat seriously and you can afford to do it, you have the privilege of that. It's usually safer, to just get it done so that you're ready to go, so that you don't have to clean up stuff, spend more money, or end up in a dangerous situation. However, not everybody can always afford that. Even a couple $100 or $1,000 is an outlay that isn't ready until they want to prove something. Some value is created, some market validation exists for what they're trying to do. So the third thing is when there is something at risk. In Juan's example, like money was at risk. So totally there should be a legal entity there. But if you have customers, potential revenue, you're building out a team, anytime you're trying to create relationships between more than just yourself, the best bet is to actually have some meaningful contractual relationships rather than just handshake agreements. Often you'll see founders who worked together and they say, we really trust each other. We'll just go and do that stuff when we really think we get some traction. It can work out. People can have longstanding, relationships and trust, but a lot of times the act of creating an entity and the decisions you have to make to fully form it often really lock down how that relationship is going to function. And it's a really useful conversation to have beyond just, liability and bank account stuff. And then externally, outside of just the founding team, IP, assets, revenue, signing agreements with partners, like all those things, they're going to start to create value in the company. Even if it's a small amount, you want them associated with an entity rather than just you as a person. So we're going to jump into the two most common types of corporations, an LLC or C Corp. Oh, cool. We got a good question from Dan. Let's say you have two friends and a dog working on code. They're starving grad students and the idea is speculative. So an LLC seems like a lightweight entity to hold their work together. Time goes forward and they want to get more people and money involved. And now a C Corp starts to make more sense. Can you talk about the transition? Totally. That actually comes up in a slide in a couple. So I'll hit that up real soon, Dan. So before we jump into that, let's actually talk about what the difference between an LLC and a C Corp is. LLCs literally stand for limited liability company. Generally, they're appropriate for services-based businesses like consulting, businesses that intend to be revenue or profitable in a short order. Also things like hedge funds. There are certain businesses where the corporate structure is not necessary and or the way money is moving around fits an LLC. It's kind of interesting. It's like LLCs are often for like small, non-high skills, companies like agencies, consultancies, dev shops, and then also super high fin stuff where you need like custom operating agreements. LLCs are slightly cheaper to set up and keep compliant annually, only on the order of a couple $100. There's no concept of shares, which complicates equity ownership, not fractional ownership in your company. You'll often have what's called an operating agreement that you can take templates online, you can work with the lawyer to set up. One of the biggest differences is the tax on the profits of the organization gets passed through to the owners. So if I just set up a sole LLC, or to Dan's example with two friends and a dog, if we make any profit, it just flows through to us based on our ownership agreements. And we count that as ordinary income tax based on our income tax bracket. The entity itself doesn't have to pay taxes. Institutional investors don't generally invest in LLCs. Again, to Dan's example, once things starts moving, usually companies get pushed to be a C Corp, if not a Delaware C Corp. There is a plan, and we'll talk a little bit more about conversion in a ghost story in a little bit. But if you start with an LLC, you can convert it into a C Corp. You want to be sure you're in a state that supports something called statutory conversion. So if there's any kind of upside idea or high growth or outside investment future for your LLC, make sure this state you started it in has statutory conversion. The other alternatives are much more expensive, and we'll get into those in a little bit. So now let's look at a C corporation. Yep, I will do that in just a second, John. So the difference, the C, this is the hardest thing to Google in the world. C comes from the tax treatment. It's not a redundant name. Subchapter C with the IRS is what defines a corporation. All 50 states have basically C corporation-like. It is the most common type of corporation. Honestly, 95% of all public companies are Delaware C corporations. And they have three very important structures: a board of directors, officers, and shareholders. And those different roles are how the company actually runs. And the equity ownership in the company is split in two shares, which is, when you talk about public companies, literally a share of stock is one vote, one slice of ownership in the company. These are by and large the preference for institutional or professional investors. When I say professional investors, a term that goes out on is professional investors and unsophisticated investors or unaccredited investors. Professional investors are investors looking to make money or a return on their investment. So there is a numbers game approach to it. They might be motivated by passion or impact or other things, but what they want is assurance that if they put money into this company and this company is successful, they will get a return on that. An entity like an LLC, each one is kind of custom based on their operating agreements. So there's no real case law with a body of case law like there is in Delaware that gives investors the comfort that things will work out should things work out for them. It's really just, Delaware makes literally 25% of its revenue on Delaware franchise taxes, which is running corporations. It's a huge part of the state. They have probably the most mature courts that have corporation-friendly law. Corporations do not have that pass-through taxation. So the corporation itself is taxed on the profits it makes like an individual would be. The corporate tax is quite a bit lower than income tax at the moment. But this is often a bit of a smokescreen that you'll hear a lot of people, and especially local lawyers at a local level, will give advice of like, oh, don't go with C corporations because like you'll get double taxed. The vast majority of startups, that doesn't matter at all, because most startups do not have profits for a very long time. And by the time they get to that level of profitability, they've probably been forced to get into C Corp anyway, whether it's taking on investment, needing to grant stock options and things like that. Most C corporations spend more than they make, or if they are getting your profitability, they reinvest it into the corporation in terms of hiring and research and development and things like that. So that double taxation isn't as much of a boogeyman as some people make it out to be between the LLCs and the C Corp. Another advantage of C Corps is you can have multiple shares of class, so you can have preference stock, you can have all sorts of different well understood and well controlled mechanisms, or control mechanisms for the corporation. And those are also something you can sell to investors for more than just what the common stock is worth, which is generally how companies raise funds. All right, so the big question everybody asks, can't I just switch at some point? And usually you can. But it can get costly. And if the upside to your venture, that especially if you're just starting out, has any reasonable chance of taking on outside investment or going the stock plan, it's usually cheaper just to start out with that. If your C Corp ends up turning into a sustainable kind of lifestyle business, you can change it into another thing if that turns out, but usually the costs are pretty weighted. So here's an example, and then I'll get to John's example with an interim. But somebody wants to start a local LLC just because they got advice from a lawyer that they talked to that, hey, go do that, you're going to start a business. They also work with that lawyer to set up some operating agreements. They ask about the business, you get some custom drafted stuff. It feels good because it seems like you're doing business and making progress. They hire a dev shop, they build some stuff, they promise some kind of ownership. If the co-founder joins them, it's kind of we're not going to really pay for it yet. And they get some interest from an investor, and the investor's like, no way am I going to invest in an LLC. You need to become a C Corp. Now they're going to have to go back, and especially if they built something, they have IP, maybe they have revenue even, or like customer list or something like that. They're going to have to pay both a lawyer and accountant significant billable hours wage to go back through and find the history of everything the LLC's done to figure out what they call a plan of conversion over into a C Corp. And the longer you go as an LLC and the more assets you accumulate, the more expensive this can get. Because you're really kind of rewriting history, looking at local state laws, depending on the state that you're in, looking at the laws of the entity that you're trying to convert to, and just making sure you do everything right. A lot of times there's income tax events at the state that you were with the LLC in, and now that you're moving out of the state, so there's other outflows to the state as well, taxes, fees, things like that. So what this can really come down to is you can raise a pre-seed round of a couple $100,000 and spend a good chunk of it just getting your entity into the shape that it can take the money. Dan, does that help answer your question?
Oh yeah, that's great. Thank you.
Can we talk a little bit about the little hand wave you did about different classes of stock and
Sure.
why you might want to have different classes of stock? And specifically, I'm trying to relate this in my mind to the crowdfunding stuff, where I might want to do crowdfunding on one class of stock and do ownership on another because there's some specific things I want to avoid.
Yeah. So by default, most C corporations start with just common stock. And that is one share, one vote. Usually common stock, you don't move around a lot. It's not intended to be, freely traded or anything like that. So there's a lot of transfer restrictions on it. And usually that's what the founding team gets and some early shareholders if you don't have an option plan yet. You might have an advisor, or maybe you're hiring a contractor firm and kind of sweetening the deal by adding a little bit of stock grant to it. Later on, when you go and raise funds, often you don't just sell off your common stock, because for the most part, even companies who have built an app, their common stock's not really worth all that much. You create it at a very low value. And if you were to sell it off at more than what you created it with, like we start all of our companies with 10 million authorized shares, each share is worth $0.00001. So it's like 1/10 millionth of a dollar. What that allows the founding team to do is buy that stock very cheaply, which is a good thing. So that if they create a ton of value, they can later on sell it for a huge difference. However, 8 months later, 9 months later, if you're going to get some investors, you can't say that the stock's worth $1 now, because you're basically pricing your company. You're putting a value on your company, which is something that you generally don't want to do unless you're really confident about what that value is. So traditionally, when companies would raise money, they would go to the state of Delaware and they would authorize a new class of stock, and they would call it preferred stock. Preferred stock would come with extra preferences, rights, conversions, tag along rights, drag along rights. There's a ton of different things that you can put on preferred stock. But by having all those additional preferences or terms, you can arguably sell those for more money than what the common stock is worth. So this is what a priced round generally was, and how seed deals used to happen decades ago. You would convince investors like, oh, we're going to authorize this new share. They're buying half into the speculation, half into the value created already, and you can justify selling those at 50 cents a share rather than the fraction of a share or fraction of a dollar that you previously did. Additionally, and more recently, there's been some other classes of shares that we've been talking about. One is called Founders Preferred, which is having some preferred stock in the initial founding of your company that you can then later use to sell to investors. And then another thing is crowdfunding. So crowdfunding is really interesting right now. What we've seen from a number of the portals like Start Engine and WeFunder is they are selling common stock, but it's common stock without voting rights, or common stock where the voting rights are actually proxied back to the CEO of the company. And the interesting thing about that is, depending on what your company's trajectory is and who your audience and your customers are going to be, there's different kinds of incentives there. The thing about owning common stock as an investor is you have no preference. So you get paid out at the same time as the founders get paid out. That to an investor might be actually not that great, because what if this company sells in 2 years and it's not enough money to actually make a profit for every single shareholder? A preference might be great for you as an investor because you can cash out at least. However, what it does do in crowdfunding is if you just sell non-voting common stock, your shareholders and your founding team are basically all on the same level. Usually in order to do that, you adopt different kinds of stockholder agreements for that particular sale. I know we just helped a company go through Start Engine, and they did exactly that. They sold off like 1 million of their common shares at a different price, but with a different share agreement and different terms associated with the ownership of that stock. Is that sufficient, John? Cool. And John did bring up one little wrinkle, kind of building off this ghost story, spooky story example. The journey of going LLC to a state C Corp to Delaware C Corp. Now you're talking 2 conversion events. So if you started as an LLC in, I don't know, Virginia is super expensive, by the way. Then you converted to a corporation for whatever reason that was a Virginia corporation, and then you switched to a Delaware one. You would have basically 2 conversion events, and you would need help interpreting what those looked like. I do know going from LLC to C Corp in the same state is a lot more straightforward than going hopping states. So it's probably a little cheaper, but you still have to kind of like dot the I's and cross the T's. Shawal asks, what would you recommend for someone who's exploring 2 to 3 different areas and wants to launch a company for one of the ideas that sticks? Also, once they launch that company, they want to continue working on other ideas independently. Thank you, John. You put some of the known crowdfunding platforms. Seed Invest is another good one. I like the founder of that, Ryan Fight. So Shawal, that's an interesting thought. So forming a C corporation does not bind that C corporation into their business model necessarily. A lot of people's business model and product things kind of change quite a bit over the first couple of years. So you don't have to like spin up an entity for each one. However, you do want to think about assets and IP if you're pursuing something and the company is owning it. And it's likely that maybe 2 or 3 of these different things are going to, take off as independent vehicles. There could be some thought into having different entities. Most founders I run into do not have the energy to actually make 2 to 3 things happen at the same time, unless you're literally coming off of an exit from, people always look at like the Dorseys and the Elon Musks, like how can they be running like 3 massive companies like that? Usually their first one was not the 3 at that same time. So a lot of times work on the ideas you can within the entity that you have. If it starts to get some momentum, but you want to spin it out, you can do that. It's just expensive. You can set up a brand new Delaware C Corp. You can transfer the IP over into it. You're just going to need help with lawyers and accountants, but because they're going to have to do, is it an income tax event? Is this company losing assets and value and things like that? Cool. So that's not it. There's other entity types. You might have heard of SCorps, benefit corporations, all sorts of things like that. There's a lot of confusion in this area. So we'll start with S-Corps. S-Corps are not an entity type of it themselves. They're actually an election that a C-Corp can make annually. And what it is taxing the C-Corp like an S-Corp, or I'm sorry, like an LLC. So they get that pass-through taxation treatment. Sounds kind of like the best of both worlds, but it does come with some weird stipulations, and it might cut off some paths of like future growth. So by doing an S-Corp election every year, you're basically saying, hey, we're a C-Corp, but we're really going to be tax licensed S-Corp. So all the profits will flow through to the owners of the company. But that puts a bunch of restrictions. So you can't have investors outside of the United States. You can't have more than 100 shareholders on your cap table. And the biggest thing is there's something called QSBS, which we'll get to a little bit more when we start to talk about equity. But QSBS is one of the biggest upsides in the angel investment and founder space for US-based companies. And what it stands for is qualified small business stock. If you are granted stock, it is a tax treatment for profits made off of selling stock. So as an individual, if you are granted stock in a C-Corp that stays a C-Corp for 5 years, as well as doesn't move that stock around or redeem it in some crazy ways, you are eligible to not have to pay gains on up to 10 million of appreciation on that stock, which is huge. It's huge for founding team because you're going to have millions of shares of it. And it's also huge for angel investors because it's per company. So what this was designed to do is to get people to put money into private companies, help them get off the ground. If I'm an angel investor with a portfolio of 60 companies, that's 60 shots at $10 million of tax-free gains, which is a massive incentive for investing in early private companies. The crazy thing is that being a C-Corp for sufficiently all of the holding period, that 5-year holding period, is something that doesn't have a lot of case law around it. There are lawyers out there who said taking even one S-Corp election for 1 year will invalidate that. There are some people that say maybe 1 or 2 years you can get away with it. Nobody has really taken a hard line on it, and there's not a lot of precedent to point to. So the majority of people we just advise is to just stay a C-Corp if QSBS is important to you and important to your future investors, because you don't want to lose out on that. B Corps, one thing you could think of is if you were going to an approach of like, I'm going to start a services-based business. It's going to turn into a product-based company or something. If you're playing real like banker next level chess with your entity types, you could maybe be an S-Corp for a couple years and not grant the majority of your shares, and then later on grant those shares when you're going to just stay a C-Corp. But that's the kind of, you're doing a sort of needlework that you're probably going to want to help with, or you might already have a legal background. B Corps is another one, increasingly popular. A B Corp looks and operates just like a C Corp, except they have one thing on their charter that also says there's a public good or a benefit that they're going to pursue. The nice thing about B Corps from like a trying to help the world standpoint is traditionally C Corps basically have to enhance shareholder value. That is like their goal. So you can actually have, once you have lots and lots of shareholders and boards of directors, like there have been high profile cases where CEOs get kicked out because they didn't do a deal that would have made their shareholders, millions of dollars. But B Corps can actually say, hey, the public good that we're reporting on annually can actually factor into the decisions on how we operate. It is worth saying you will see B Corp certified on companies. That does not mean they are necessarily structured as a B Corp. There's a B Corp certification entity out there that basically just looks at companies and if they are actually doing a benefit beyond just making people rich. But often you see one and the same, that they start as a B Corp and they also get B Corp certified. Dan said, John put some good stuff on QSBS in the chat. I'm unfamiliar with the self-directed IRA stuff with Peter Thiel, but we can probably bring that up in the end.
Yeah, I think quick Nash, QSBS is on the chopping block federally. So that's likely what it refers to.
I see.
Or in jeopardy, not necessarily on the chopping block, but in jeopardy.
Well, I think
Hi, Pete. This is Pete, by the way, my day-to-day companion and CEO of Gus at the moment. Cool. So,
hi there. The deal with Peter Thiel is around Roth IRAs. And Roth IRAs are different than QSBS, fundamentally different structures. They're both under review federally, but it's worth saying that as an accredited individual, if you have a Roth IRA, you can invest out of that Roth IRA. And any upside is untaxable. Then there's no limit, by the way. There's no $10 million limit to the Roth IRA. You can put as much in your Roth IRA stock as you're able to gather. Anyway.
I didn't actually know that. Cool. So we good to move on? All right, so let's talk about, assuming you made the choice of entity type and you're going to pursue a Delaware C corporation based on all that stuff that I just said and tried to convince you to do so, if your startup has a chance of growing and doing all those things. Again, the three tiers we always ask is if you plan on raising money from professional or professionalish investors, if you plan on giving stock options as an incentive to early employees, or if the end goal for your company is like an M&A or an IPO. If any of those have a reasonable likelihood of happening or being your intent, you should probably start with the Delaware C Corp just to make things simple. So what is it actually setting up an entity? So the first thing is literally just filing a piece of paper with Delaware. It's called your charter, your certificate of incorporation. It's where you lay out, like, basically you're going to do business well and you're not going to be a crook. You say how many authorized shares your company has. 10 million is overwhelmingly the standard because it can model pretty much any equity ownership in the early days. And you also set how much those shares cost, the par value, which is the lowest value in which they can be purchased. Like I said, a very low value is common, like our 4 zeros and a 1. And once you're filed in Delaware, what that basically gives you is access to their courts. They will say you're in good standing if anybody checks, as long as you've been paying your taxes and keeping up to date. Those franchise taxes are not the income tax we talked about earlier, but rather it's kind of like a listing fee for having access and being on file in Delaware. They calculate them in some fancy ways. If you have so many shares as 10 million, you'll often get a big scary $80,000 check for your first year and be like, what? But there's a different way to file your taxes if you're a startup like that. We guide people through it on the platform every year, and it's basically just choosing a value that's based on the assets your company has and the issued shares. But don't forget to pay that, because there is interest and back fees if you miss it each year. And if you fall out of good standing, Delaware will administratively dissolve your company after 2 years. So you want to keep up to date on that. You also need a registered agent, somebody who's basically going to represent you in the state and give you important state notices. Once you get that paperback, it's not enough. Literally, that's just you're on file there. You want to actually set up governance, which is basically established bylaws, which is the document that says how the company works, votes, makes decisions, who's authorized to do what, appoints the officers. So you'll have at least a president and a secretary. The president and CEO is often a merged role. You can optionally have a treasurer. Those are the only roles that Delaware actually cares about. So the CTOs and CFOs and COOs and CPOs in the world, those are mostly for internal company structuring. The actual fiduciary roles are president, treasury, secretary, CEO. So you want to be sure you do that. You also want to be sure you appoint the board of directors. The person that files the filing with the state is actually called the incorporator for a bit, and their job is to appoint the director and then kind of resign. And then very importantly, you're going to issue shares to the founding team. So there's actually ownership. It's very important to set up those 3 tiers: that directors, officers, shareholders. And we'll get into why in a second. And the last thing to register and consider, if you're not in Delaware, but you're doing business out of a different state, which is most people, you also will have to foreign register in the state that you're doing business. This is often called forward qualifications. Some states call it the authority to operate, or various other things, but it all comes down to basically your entity is technically foreign to where you're doing business. So you have to register with the state. Each state is a little bit different. Some are very expensive. Some have annual requirements. Virginia's like $2,700. California is like $400, but they charge $800 a year in like their own version of franchise taxes. If you're distributed or you have some options of a different state where you're going to have an address, it's worth looking into the state's requirements to see which one, the ongoing responsibilities and just the overall costs. Let's see if I get these questions. Some of these questions are a little all over, so I'll get them more in the end of the Q&A.
Yeah, I'd say maybe touch on 83B quickly.
Yeah, 83B we have in the next slide when we're actually.
Okay, cool. So, and we do have a question about the meaning of doing business in a state, which might be.
Oh, yeah. Yeah, so Pete, if you could watch the chat now and pick things out for me so I can deal a little more with Chloe. So doing business. It is, no state will tell you what it means. They basically want to reserve the right to say you were doing business if they ever want to cut of what you're Many states will trap it around like, sufficient transactions or having an office or having an asset or a warehouse or an employee or a certain kind of employee. Salespeople seem to be really popular among states. The long and the short of it is usually if you have an office and address where you're doing stuff, an employee, or you're transacting significant amounts of things from residents of the state, you'll probably want to foreign qualify there. There are some states that are a little bit more lenient. Texas is known that you can probably have your whole founding team in Texas just working on an MVP, and they won't really care until you're actually transacting like real transactions. But it's worth looking into some of the state's requirements and the fees, especially if your state has a lot of back fees. Again, using Texas, just because one of our law partners actually has a good blog post about it, the cost of not foreign qualifying there is that you just have to pay the fees that it would have been if you had foreign qualified there. So it's like, you can wait, but other states are a little bit more, they're jerks. So. All right, so this sounds like a lot, getting all this set up. Like, do you really have to do all this? And like I said at the beginning thing, it's like, have to? No. You're a brand new company with no value, no assets or anything like that. The state's not going to come after you. Delaware's not going to run over to you and be like, hey, why didn't you issue shares or anything like that? Nobody's going to send you a letter. However, if you haven't done this stuff, things can happen. And so fictionally here is somebody who starts out with a CCorp. All right, points of self-director, we're doing well. Doesn't issue any shares because they're not really sure. Maybe they'll have a co-founder or not. So they just kind of let that languish for a bit. And they weren't even aware of foreign qualifications, so they don't register, but they're working on their company. Things are good. Things are really good. They actually start making revenue. They've got a product market. They have some customers. Finally, like enough money is changing hands that they get a bookkeeper and a tax accountant to like figure things out, only to realize like they owe a bunch of back taxes. Now there's fees and interest that's collected. Oh, they should have foreign qualified in that state before, and they're going to have to handle that stuff. We're overdue on franchise taxes. And then things get really bad because of some of that. They're focused on something else and somebody sues them, a customer or a vendor or something like that. And as the lawsuit progresses, it turns out this company never had any shareholders. So it didn't actually have the corporate veil. This person was really what they call a shell, where they're just a director of an entity without an actual properly set up governance structure. It's potential that that lawsuit could actually go on to the person rather than the company.
I think one other good thing to touch on there quickly is the not granting shares piece. As you're accumulating value in the company, your shares are increasing in value. So if you do things like promise equity, but never grant it, but you accumulate a bunch of value and then go to grant it later, you are eliminating a whole bunch of monetary advantage for yourself. Either like the cost to buy into those shares is going to be huge, or if you don't pay for them in cash, you're going to have an income tax event on an illiquid asset. Or, somebody is going to see that they got shares at X instead of X, shifted over a whole bunch of decimal places. And now the delta between that and what they eventually get to sell for is squished.
Yeah, we're jumping into the managing equity piece. And one of the big things to always come away with is you can't grant stock in the past. So like if you miss the chance to grant stock at some given point, you can't fix it up by being like, oh, I should have had stock 2 years ago, because that is obviously like a huge fraud issue. So let's talk about equity in general. So now I said you need to have shareholders, or shareholders are also complicated in certain ways. One of the most important things is just from a startup is having a frank, open, and transparent discussion about the equity split between co-founders. Somebody who jumped on earlier said, oh, we have about a 50-50 split. There are ramifications of that, and often it's not that simple. The roles that people play in a company, some are absolutely essential, to whether it's fundraising, domain experience, the chance to success, the personal network, the connections, how much money themselves are going to put into it. All these things influence what ownership is, and it is rarely a 50-50 scenario. It might be 55-45, but it's really worth having that conversation up front, because as things start to happen in the first year, you really start to feel the roles and who's like a real good fit and who's going to stick. And there's some protections that we'll talk about in a bit for that. But it's not a thing to consider lightly. We actually we have a free tool at cofounders.gus.com that walks you through all of those abilities to add value, or the dimensions of value creation that go into an early company. And each member of the founding team can go through it on their own. And it will give you a sample split at the end, literally down to like 36.2 to this person, 25.2 to that. It's not meant to be immediately plopped onto your cap table that way, but it really helps fill out the whole conversation around who's in for what role and for how much. Also be sure that once you have an idea of that split, you don't just handshake deal or email thumbs up it, because the promise of equity is not the same thing as issuing. You need to issue the equity. You need to have the document signed for ownership to actually be complete. Another thing that companies often get tripped up on is, previously I said a lot of companies start with 10 million authorized shares. Just because you have 10 million authorized does not mean that 1 million of that is 10% of the company. Ownership is only ever at a point in time, and it's only based on the shares that are issued. So if I have a company and I issue 1 share to me and 1 share to Pete, we each own 50% of the company, even though there's 99.9 whatever million authorized. The only issue is that right now. Worth saying, never just issue 1 share because it has horrible Delaware franchise tax issues, but just as an illustrating example. So a lot of times, especially in the early days of uncertainty, you want to leave room for some flexibility. You know, we often advise, founding teams to issue between 6 and 8 million of their authorized shares as they're getting their founding team stock nailed down. That gives them enough flexibility for the future to carve out an option pool should they raise funds and put an option pool in there. Also to incentivize early team members that aren't just the founding team, like I said before, contractors, advisors, things like that. If you're 6 million or 7 million, like that's not going to be a huge issue. And I said before that common stock is for founders and early team members. You don't sell it to investors. This is when you'd go and actually authorize more shares. We kind of covered that. And because of all the complication that I spoke of about creating preference stacks, figuring out all the possible terms of them, most startups do not go and raise a price round as their first pre-seed or seed round. They often use instruments called safes and convertible notes. These are convertible instruments that are designed to turn into equity in the future when you do create those new share classes, but they're designed to be executed faster because they defer a lot of that negotiation and term setting to that future round. So it's a way for investors to get, checks of like $20,000, $40,000, $50,000 into a company with some protections and some incentivization upsides for taking an early risk, but they don't become equity owners in the company until that price round happens later on. And so the most important thing on these common grants, whether it's your founding team, whether it's a contractor you just hired, an advisor, is pretty much all these grants should have vesting schedules on them. Even though it's common stock, it's not stock options, so this isn't stock option vesting, but it's technically called reverse vesting. And what this is it protects the company's ownership structure because it is the right for the company to repurchase shares at the same value that they were granted, par value, automatically in the event of a termination. And so vesting usually has 2 components: the overall length of the vesting schedule. A very common one is 4 years for founders, and then a cliff, which is a period of time where no stock is vesting until that cliff hits. So the most common schedule here is 4 years with a 12-month cliff. And this is very popular, common among founding teams. That means that your co-founder that you granted 3 million shares in your company does not have, the company can repurchase those shares if that co-founder leaves the company. For the first 12 months, they can repurchase the entire grant so that the company won't lose that chunk of equity. If they pass that first year, then month to month after that, they will vest 1/48 more of it, as well as the first whole chunk year. What this allows companies to do is start relationships with contributors to the company, understand that they own, they have the voting rights, they own those shares in terms of how operating the company as long as they're with the company. But if they leave the company has a protection that it's not just sitting with 10% of its cap table where no one's contributing to it at all. So yeah, that protects the companies. It also protects QSBS status in terms of the repurchase rate is baked into the grant. So it's an automatic thing. It's not like you're transferring, you're buying out your co-founder or anything like that. It's just built into the contracts. And then last but not least, if you have vesting on your stocks, that means that in the future, the IRS considers once a piece of common stock is vested and the company has lost the repurchase right, the individual now owning that has just had an income event because they just received a piece of property that nobody can really easily take away from them. If your company is growing in value and things are going really well, you do not want to be having income events every single month for your company that you're putting your blood, sweat, and tears in that is going up in value. Because like Pete said, as value gets created, those shares stop being 0.00001 and they start being 50 cents or $1. And if you're getting 20,000 of them invested every month, you don't want that as your income as well. So there is a thing that you can do for that. You can file an 83B election with the IRS, which basically says, I want to pay my income on this stock vesting all at once, all up front. the stock's worthless. Great. Here we are. It's not an income event because you pay for it all in cash in the same year that it was granted to you. The craziest things about 83Bs is they need to be done in 30 days from the grant date. And the IRS is pretty stingy about missing that window. So, and you need to have a wet signature on the election itself still and mailing it to the IRS. It's a big pain. We try our best in the platform. We literally give you instructions, a cover letter, and self-addressed stuffed envelope style, wet signature stuff. But founders still miss this stuff, and it's a pain. So
so Nash, two questions on that before we move on. I can take the first one because it's relatively easy. What are income events? Common stock does what's called reverse vesting. So when you're granted restricted common stock, you immediately get the voting rights and the corporate governance rights. But if they have a vesting schedule attached, the company retains the right to repurchase any unvested shares if you leave. So what the IRS says is, hey, we only care about vested shares because until then you have a substantial risk of forfeiture. So if you have a vesting common stock grant, each vesting event, which typically happens the first time after some cliff, which is usually a year, and then monthly afterwards, each of those vesting events represents an income event for you personally if you have not taken the 83B election. And then Nash, we've got in the early stages of a company, really hard to say which founders' roles need to be assigned more ownership. In later stages where it becomes obvious, are there any adjustments that can be made to make it fair?
Yeah, that's a great question. And it sounds like you're thinking along the right lines. So first is using vesting schedules and that upfront conversation to figure out where we think those roles are going to be and who's going to be into it. But, set a good cliff, a year or more. And as you figure out what's actually happening, I just had a founder I was talking to last week where it's like they have a lot of like junior contributors that want to start out in the beginning and they're not sure who's going to stick around or whatnot. But you can always grant more stock. So if your situation is full of extra uncertainty and you're not really sure if these roles are right, set a vesting schedule with a good cliff and an amount that mirrors kind of an agreed upon state. And if more needs to be granted in the future to compensate for somebody who's really just like doubling down and providing a ton of value to the company, that's an option that's open to you rather than trying to fix up grants or do anything tricky with that. Often you'll hear people throw out milestones as being like, hey, can I associate vesting events to like things that are happening in the business so that if somebody does really well, like say I hire a salesperson or a sales contractor, and if they land X amount of deals, like we'll give them X amount more equity. It sounds really fun, or it sounds kind of like a really good idea, lock in business success with equity success. But startups are so uncertain, things are changing so much, it's often way too much hassle to manage because those terms, one, you're probably going to want a legal opinion to actually spell out appropriately in a comfortable way for both parties to feel like they sufficiently cover the milestone. And two, the milestones change all the time and you don't want to go and amend vesting schedules all the time just because your business is pivoting, things aren't going the way you thought, you're going into a different market. It's usually best to just find the right time, put a smart cliff in place. There's even been some talk recently about 6-year vesting schedules or longer because companies are staying private longer, or deeper cliffs. But you can kind of play with those a lot more easily than you can play with buying stock back and transferring it back and forth. So it's good to put a lot of thought into the vesting schedules and possibly future grants. Like Pete said earlier, if you are doing a future grant, it is possible that the company is increased in value and it's not going to be as cheap. You can buy 2 million shares in a Delaware CCorp for $20 when the share count is 0.0001. But a year later, if it's 0.001, it's going to be a little bit more expensive. And that's where a company can also think to switch over to using stock options, where the employee doesn't have to buy them up front. They only have to buy them when they exercise them.
Yeah, I'd say generally too, each round is typically a point in time where you can start to adjust these things and think about refresher grants. The more progress and traction you make, the more likely it is those things are able to get done and negotiated by the founders in those rounds. And Nash, Dan mentions founders bring different things to a venture: money, expertise, and maybe existing work. Cash is king, so you shouldn't need to vest a cash investment. But what about a bunch of code, say an MVP? They would need to assign it to the entity, but should they be treated preferentially? I'll take one of those real quick. In terms of cash is king and that investment shouldn't need to be vested. That's typically not what we see. The first is that founders aren't usually investing large sums of money directly in exchange for their common shares. So they're not papering the transaction as I'm going to put 10K of my money in for my common stock, because that would put a price on the common stock prematurely, which would make it more difficult for them to compensate or incentivize other early team members or limit the amount of upside that those early team members will get. So typically what we see is that the ownership is still vested, even for people who are putting in the money. And then that money is either papered through a simple loan structure, or in the case where they are bringing a significant amount of money to the table. We have also seen founders essentially treat themselves as investors and invest through a convertible instrument that will then convert later. And Nash mentioned this a little bit prior. One other thing that we've seen evolving in the space is the notion of founders preferred stock, which is typically about 10% of the total authorized. Those grants are made as vested stock. And because there are additional preferences, there's a justification to price those shares higher than the common stock. So that is kind of a convention being developed so that founders can paper their initial cash infusion through an investment into founders preferred shares and also preserve some liquidity. We haven't, or lock in the ability to have some liquidity at a Series A. We haven't seen that become standard enough. And one of the things that we often advocate for is don't put preferences for yourself in place until you've demonstrated the traction to be able to argue for them. So we're kind of on the fence about that one, but it is a more and more common way for founders to inject that cash in.
Yeah, and I guess the last way, if the amount of money is substantial, like most investors expect founders to put, low thousands a month into their company to like pay for things and get it off the ground. And that's really just like kind of the expectation that you're doing that and your daily efforts and you're contributing to the business to grow it. But if, say, at some point the business needs $100,000 to operate, there can be an occasion where a founder will actually act as an investor and write themselves something like a safer convertible note for a big chunk of money that the company uses. You have to be sure that the narrative stacks up. So when you're talking to investors, you're justifying that in that case, because otherwise it might be seen as double dipping where, hey, you own 60% of the company in common, and when you do a funding round, you're going to get X% more. Like, what gives? But if the money's big enough, it can sometimes make sense.
And yeah,
sure. I was going to say the other part of Dan's question is outside of cash. So if you're transferring a pre-existing something like code or IP, well, first I guess saying like in the most straightforward example, two people are decided to start a company. Chances are they built something. Something has been generated, whether market validating or something in their own hobbies or something like that. As long as it's not something like a cash generating web app or something like that, a lot of times all the founders should sign a founder IP assignment, which says anything I built for the purposes of this company and going forward, anything I build will be owned by the company, and everybody should be bringing something like that to the table. However, if there was something that is sufficient, like you had something with customers, something that was generating money, a proprietary invention or something like that, like a patent, and you're going to bring that into the company and basically license the company to be able to use that, that is going to be an asset that does have value and adds value to the company as you bring it in. So you'll want to make considerations on one, does the value of the company actually spike to a point where it might not be able to grant a common? Two, is the ownership right? You're probably going to want to work with lawyers to figure out how to do that appropriately and how to price that, as well as whatever entity or individual is leaving might have some kind of taxable event. Excuse me. What else you got, Pete?
Just the last piece, John's follow-up here. So yeah, with the founder preferred shares, the shares are intended to be offered and automatically convert to preferred shares at that Series A. And then the investors in the Series A will essentially have the option to purchase those from the founder. If they decline that option, then typically those shares will turn into common at that point.
Yeah,
I believe that's right. That may not be exact.
It's an interesting thing we're seeing, getting around the just doing a low interest loan to the company to get that money in. I will say I've seen a lot of companies start out with it and then be like, yeah, we're going to get rid of that. But we'll see how the market goes.
So one of the things that we have seen in some European countries is that the pre-seed and seed investors frequently get bought out by the Series A investors. And so they're not getting crammed down like we see here. They're getting actually returns early, and getting a fundamentally different model on their investment. And so I wonder if there's not a founders preferred shares kind of model for pre-seed investors that would get
Angel
them,
preferred.
yeah, angel preferred, that gets them out of the deal so they don't have to fight with the Series G idiots that are doing weird things, right?
Yeah, and that's actually really interesting, John. I think that might actually go a long way towards bringing a price round back at that level with the types of investors we're seeing be involved in the space. So we should keep talking about that.
Yeah, can we have a dialogue offline about what it would take to put a piece of paper together around that?
Yeah, absolutely.
That'd be great.
And let's see, Shreya asked, if it's just a little bit of money, low thousand, should both founders invest the same amount to keep things simple? I think it doesn't really matter if the amounts over time are the same. Essentially, when you do that first co-founder equity split, you are doing that prospectively and ostensibly for the time period that the vesting covers. So you are setting expectations for the amount of money, time, IP that people will be contributing. After that, the amount of money you're putting in isn't directly affecting your share count or anything like that. So as long as what you're doing founder by founder is living up to the expectations that you set, everything's great. And as long as you paper it in some way, then you should be fine from an accounting and bookkeeping standpoint.
All right. I gotta go right now. I think this is my last horror story, and I tried to be really crazy with this one. So this is all like things that can go wrong. When people start getting custom, they're just using templates and filling things out and getting half the advice. So say we got Max starts out with the Delaware CCorp, but only rises 500 shares. They read somewhere that anything above a couple thousand causes bad tax consequences. Who knows, whatever. Let's just do 500, and they price them at 10 cents each. Grants 300 themselves, 180 to the co-founder, so there's only 20 left. That was the split that they talked about, but then the co-founder leaves. There's no vesting on the shares, so you can't exercise that automatic repurchase right. So they argue and whatnot, and eventually the remaining one buys out the founder, gives him a bunch of money, just to get him off the thing, and it's like, all right, I have my 480 shares back in their mind now. Chances are those repurchased shares, depending on how they did it, might lose the QSBS status. And founders trying to make things work, finds a great contracting firm, you can't afford them fully, but can pay under market and then maybe promise them some equity, but only has 20 shares left. You can't vest 20 shares over 48 months all that easily. So how are we going to do? Oh, we'll go back to Delaware. Now we're going to file an amendment. Now we're 10 million shares. We read that 10 million is good. But now a 5% stock grant to that contracting thing costs $50,000 because we didn't change the par value on them rather than the small amount that it did. We can do more amendments, which also cost money. Amendment with Delaware costs a couple $100, $450 or so. Generally, it's a pain. So all this mess is set up, but they finally get investor interest, and now the investors are asking about like, well, wait a second, you paid money for shares back from your founder way back when. Your company was worth X times those shares, right? And it's like, I don't know. And also, like, what happened with that? Like, you're just in a mess where even if things go well, the amount of corporate cleanup you're going to have to do is going to cost you lots of legal time and accountant time to set the story straight, to be sure that the things were done. And it's just a hassle. So, yeah. So the last thing is, assuming we set all that stuff up, and we talked about this a couple times through the task, is like, what actually gives a company value? And Dan and a couple of people in the chat were saying these, like, mostly cash, if you raise funds or you have money in the bank and revenues that you generate. IP, the things that you build, whether it's software or patents or ideas or processes or anything like that. The people in your company and their experience. Equipment and assets, customers, contracts, and orders. So these are all the things that as they flow into your entity, you can meaningfully say the entity is getting more and more valuable. And these are the stories that you start to tell when people do say raise funds and they say, well, the pre-money valuation was X millions of dollars. And that is accounting for the actual accounts. Like, this is how much money we have. This is our revenues. This is our assets. These are our liabilities. And then the story and the idea of like how much money and value can this company continue to create if they keep doing what they're doing and do more. So as you're building that, and hopefully you are, you want to be sure to protect that. So all the stuff that we covered is making sure that that value isn't leaking out of the company or becoming so expensive to protect later on. So be sure you fully establish all three levels of the company: directors, officers, shareholders. Don't have your finances all mingled up and confusingly spending money out of your own checking account. If you're going to put your own money in the company, figure out a way to paper it, whether it's a loan or some of the more creative stuff that's coming out. Be sure that the company owns all of the IP that the founders are generating, or anything that might be assigned or given to the company. And any kind of role you're going to have external, whether it's a contractor, advisor, just working with a vendor, you want a piece of paper that identifies what that role is, what they call like a service provider relationship. One, because it'll come up in diligence if you're saying, oh, we have these great people on our advisory board, and then there's nothing papered with them. Like, that's a red flag in an investment conversation. And then again, be sure you've taken care of ownership. Every equity grant has a board approval on it. The vesting schedules are in place. All the documents are signed. For all your common stocks with vesting, be sure to get 83B elections individually for your own stuff. And all this should boil down to is tracking this on a cap table. You can get away with spreadsheets, but if you're not marrying the documents with the rows in the spreadsheets and you're not constantly keeping it up to date and shoring it up, there are many, many chances for value to leak out there, things to be inappropriately papered. We would suggest using a cap table software. You know, honestly, it's a lot. Even Pete and I going through this, we constantly forget about a thing and remember a thing, and we've been doing this for years. So if only there was something that made it easier. We have Gus Launch. We build a software as a service platform that tries to put you on the straight and narrow for the vast majority of these. 85% of these choices are fairly standard. From vesting schedules to cap tables to agreements to P assignments. You don't want to get cute with like custom documents and constant legal review. So much of your paperwork you can do through a platform like ours. And we guide you along the way. You can see even this video, it might be a little choppy because it's a presentation, but we have contextually changing advice. We have FAQs contextually in where you're actually making the decisions, so that you're asking those questions like, what is an 83B, or what is a stock acceleration on my stock grant, stuff like that. And we support pretty much most of the standard things, whether it's raising funds through safes, all those agreements that I talked about, contractors, advisors, all into one place. It's a pretty thorough platform for companies looking to go that path. See on the right, that's actually doing the filing with Delaware and doing a little signature business. And once you get your company up and running, we even have a nice dashboard, quality of life stuff where you can see the state of any given document or agreement, who signed it when, who needs to go next. We keep you up to date with taxes and liabilities, or not taxes and liabilities, but like each year when we get into tax season, we will send you information and things like that. A nice simplified cap table so you know exactly who owns what, our own signing solution, and even modeling stuff for when things start to get interesting and you're thinking about doing a price round. And you also get us, for the most part, Pete and I and our great team. We put a lot of education around it. We do a lot of events. We work with people like John here to get out into other communities and really just help people at any given stage figure out what the next one is. And we don't think lawyers are terrible at all. We actually have a bunch of lawyers in our network that will give you discounted legal services, and we will help match you up with one of those so they can fill in that 15 to 20% gap where you do need to talk to a lawyer. Hey, that thing that somebody built that generates revenue, the company wants to buy. How do we do that? How do we be sure we take care of all these kind of things? That's where you want to spend money on legal work. You don't want to spend money on a lawyer explaining to you what an 83B election is.
Yeah, there was a question about services like Stripe, Atlas, and us. Atlas is a competitor. There's also Clerky, there's CapBase, there's a new product from AngelList. We try to differentiate because we are startup experts, and we think that you should be able to get 90% of what a startup lawyer is going to tell you done without having to pay for a startup lawyer or finding one that will talk to you early on. So our key differentiators are cap table software and our philosophy on education and DIY. We really try to guide you through, educate, act as your translation layer. We'll pay for the education and help you figure out what your questions need to be. We will hook you up with a lawyer and accountant when you need one, and help you frame that question so you're not paying for extra billable hours. and we negotiate discounts with those service providers on your behalf.
Cool.
And why not Nolo, Zen Business, Stripe? Some of those have like some complementary stuff. Stripe is ramping back up the Atlas team. It's been dormant for a few years. They are still predominantly right now focused on incorporation, not helping you through all the stuff afterwards. You'll get templates, not processes and education. Zen Business, I am less familiar with, but know that startups are a specific niche. So when you're looking for startup legal services and startup lawyers, you do want somebody who understands the startup and venture landscape. That's our area of expertise. So if you're going to a more general provider, like a registered agent or a LegalZoom or something like that, they may have some additional legal services that you can take advantage of, but they won't have the startup expertise.
Yeah, I will say something like Nolo. Nolo is how you can get into all this trouble, because you can find slightly relevant advice and guides to like do what you think you're trying to accomplish, but get in all those things like authorize the wrong amount of shares, do a subscription agreement for the stock you gave yourself, which doesn't make any sense, but the disambiguation or the ambiguity in the space makes it so that those are general purpose legal help, but we are really kind of like guardrailed to the startup experience, which is, I think, a value, but it also means like we can't help everybody. Like we don't do LLCs. If you want a services-based business, like that's not appropriate. We're not going to do a restaurant or a coffee shop. We're talking about tech, likely high growth. It doesn't have to be a unicorn, but companies that are looking for, that sort of path.
Yeah, we do have limited support for onboarding folks who have already done some of this. So if you've incorporated and maybe you've issued stock to founders, we may be able to help you. If you've done stuff after that, it becomes increasingly difficult for us now. Something we're working on. Stripe is the default for foreign companies coming into the US. Should it be Gus launch?
Heck yeah.
Yes, we can help people residing outside the US, and we can help walk you through it for sure. And let's see. Aaron asks what entity type location you would recommend for two people in different states forming a partnership to launch an algorithmic trading fund. We would not be selling shares to raise funds, and both already have separate LLCs in our home states. That sounds like very much not our area of expertise.
Yeah.
If you both have LLCs in your home states and you are happy with that arrangement and you are happy with the level of protection you have, then continue to go for it. I would say that might be closer to fund formation than it would be to business formation. So that might be a path you want to explore.
Yeah, you missed the intro. He introduced himself as kind of like a hedge fund. Fintech companies work really well on our platform, but like specifically trading oriented companies usually have way too much regulation and they need special entity types. What else we got?
I think
Yes,
that is the majority. Yes. Let's see. Question for John. I can imagine founder-friendly terms, accelerated vesting, et cetera, that John may take exception to. Can you give some examples of things to avoid?
So what we really want from an angel investor point of view is for the founders to be incentivized exactly the same way that the investors are incentivized, so that they get to a big, healthy company that has an exit. And things that make it good for a founder, like aiming for an acqui-hire where all of the investors get screwed, really doesn't make anybody very happy. And it also makes it very unlikely that you're going to get help from those angels again, because they're going to feel poorly treated. So doing things that allow you to get everyone on the same path, pushing and rowing the boat the same direction, I think is a win. Accelerated vesting, special stock being issued in order to placate employees at the expense of the other investors, in general, is probably not a good thing. I think it's a good thing instead to have an early option pool defined and to make grants out of that pool that you've already agreed to. So a lot of early setup can make a lot of the choices much simpler in the end. But for the early angels probably have as much trouble with the Series B and Series C VCs as they do with the founders. And so protecting the early angels from that in some way is a win. What that usually means is extraordinarily simple documents, which are straight vanilla that nobody messes with some kind of most favored nation status, so that if the Series B people say they're going to do something, then whatever they do is what everybody gets. And so keeping everybody on the same page, I think, is in the best interest of the company as a whole. And then if the founders keep on a narrow path where they don't get themselves caught in a corner where they have to have that Series B funding so they can control the terms of that funding round, that'll be better for everyone, including the founders.
Yeah, and we've tried to take some steps in that direction just with our convertible stack. For earliest investment, pre-valuation discussion, we have a capless 20% discount fixed safe that has a roll-up provision. So anybody who comes in super early, if there's a capped instrument that comes next, they automatically convert into that and benefit from those later terms.
Sure. So in general, when we talk about safes, people in Seattle are nervous about safes. I'm certainly nervous about safes. Safes are designed for Y Combinator that has volume of companies they're investing in, 90% of which they don't care about because they're not progressing. And as a singleton investor that's doing the onesie twosie, I care about all the companies I invest in, so I don't want to be throwing people under the bus as I move forward. There are values to the safe, but almost all of those values are hypothesized, not tested in court. And so we don't actually know what those things really do. We have tax consequences to convertible notes. We have extraordinary math problems with stacked notes. And so my current thinking is that it's best if you figure out how to get to a reasonable valuation at a priced round in a simple document early. And so if you can get to a Series C document with a most favored nations kind of agreement with some kind of pro rata with, very little extra stuff on it, and you have a pricing that's nominal pricing, like you fill out the valuation thing on Gust and it comes somewhere close to there, then I think everybody ends up winning on that.
And John, in terms of tax consequences for convertible notes, are you talking primarily QSBS holding period?
That's one of them, but the discount generates a taxing event. The interest produces a taxing event, and so there's these K1s that keep popping up in places where I'm in 49 deals, getting 49 K1s. It's a pain in the tuchus every year. And nobody does it right. And so I have, a third of them that never show up ever. And then I have a bunch of, because I have 40 people in each round that we're in, I have a bunch of people saying, where's my K1? Where's my K1? And it's just noise, right? So trying to simplify this thing down to, I have shares in stock that will convert to shares in public when you go public, or I get a conversion of shares to the other company at the exit, seems like a really good goal. And the more you simplify it, the less the lawyers involved, the less time it takes, the more likely it is that you can focus on the business instead of the deal. And in general, if we can figure out how not to focus on the deal and just do one quick and easy, that seems right for everyone.
Awesome.
Yeah, that's awesome. We are very spiritually aligned, John.
Yeah, we should keep talking about this for sure.
Yeah, we have alone the amount of convertible instruments we've seen some people sign at like the drop of a hat. Like we have had these spreadsheets with like 3 different kinds with 3 different caps. Each one is trying to protect itself against some of the other ones, but doesn't always realize that another one is using a different company capitalization, and it's some circular math.
Yeah, and nobody can actually get the spreadsheet to settle down and give you a real number.
Well, somebody does, and then it circulates it and says, how's this look? How's this
look
look for a
alright.
pro rata
This is,
cap table?
this is truth, yes. Yeah.
Yeah, this is truth from this point forward. You must sign and accept it. And if you do, you don't get to yell about it at any future date.
Yeah. Well, having had high-priced lawyers in the Bay Area do that to us twice now, where they interpret the very plain English in our agreements differently than we wanted
Oh,
it.
you cut out, John, for some reason. Is that me?
Yeah, that
So
was
yeah,
you.
I hope it was you. It is dangerous to be having lawyers involved in the process for the investors as well as for the company.
We do have one more on-topic question here from Shreya again. How does registering in each state work with remote work? 2 remote co-founders, Seattle and NYC, registered company address as Seattle. Do we also need to incorporate company in New York?
You want me to answer that? So this is a funny thing. Founders of a company outside of California, which has some weird laws, but founders are technically not employees of the company. You don't have an employment agreement. You don't pay unemployment insurance or work comp or anything like that. Generally, you're not taking a salary. So a lot of the doing business as is centered around having an employee in the state or some kind of physical presence. So usually in the early years, you can pick one state that makes sense. Foreign qualify there. Foreign qualifying is not incorporating. You're really just letting the state know that you have a foreign business, in this case, a Delaware CCorp, that is doing business out of that state and has an address or thing in that state. So I would take a look at both NYC and Seattle, see which one is actually better or cheaper, less of a hassle to foreign qualify, and start with that. As you generate value in your business, as you maybe start to consider paying yourself a salary or hiring a contractor in one of those states or whatnot, you'll eventually have kind of an accountant and a bookkeeper to hit these questions off of, to see if you can see if you have to do it. I'd anticipate in the next 5 or 6 years we're going to have something similar to the what was it, the Wayfair law, where the Wayfair law finally put some clarity down about transacting business. I don't know if you noticed, but in the last back in the glory days of the internet, the best thing about buying stuff online is there was no taxes because you were buying it from whatever and there wasn't laws in place. Now there's taxes on everything. I literally had to pay taxes to Adobe for like an upgrade and they calculated them in some crazy way. But that's because a SaaS law got passed called the Wayfair law, where basically up to $200,000 in transactions coming from a state, if you breach that thing, the state can actually claim sales tax on that. So now you have these SaaS companies that are having to start to pay sales tax in states where they have large customer bases. I wouldn't be surprised post-pandemic, as more and more companies are becoming remote first, if we slowly start to see states address those a little bit. I hope not, but we shall see.
Yeah, one thing to clarify there is that that wasn't a law, that was a decision based on existing law, which is really good to keep in mind when you're thinking about law in the United States. And John mentioned this as well. Some of the things that people presume about safes are untested in courts. So one of the reasons why Delaware is so popular is because there is a whole bunch of case law which gives people confidence in how the law will be applied. Because each time litigation comes up or a question comes up, like the decision isn't directly based on the wording of the law. It's based on the interpretation of the law by the people, presiding over the litigation. So in lots of areas, especially in startup law, there's a lot of gray. There's a lot of, actually, this hasn't really happened enough, or the IRS or SEC haven't taken issue with this enough to have generated any hard and fast rules. So it's all based on the presumptive interpretation of the people reading the laws. And they are hoping that their perspective on it will hold up if it is ever challenged in court. So very often you will see interesting things like this, where it's like, okay, a state will say what doesn't qualify as doing business, not what does. So, you have the opportunity at some point to say, well, they didn't say it. And they have the opportunity to say, well, we would have said it. And somebody gets to decide kind of who's in the right. So when you see startup gray areas and legal gray areas, that is predominantly the reason.
Yeah, and Shreya's got one more follow-up. Does registry and address for business need to be the same state where we foreign qualify? So for the incorporation itself, you will need a registered agent and it will be in the same state. So if you set up a Delaware CCorp, you will need a registered agent that's based out of Delaware. If you then foreign qualify that company in another state, that state will most likely say you need a registered agent in that state. However, for foreign qualifications, since you're not forming the entity, you're just kind of registering it, often you can be it or the company can be its own registered agent. And what that just means is you fill that out during the filing of it. We can facilitate this, by the way. Gus Launch has foreign qualification in all 50 states. It's not included in the subscription because every single state's different. We just kind of do it as a pass-through expense, but it can make it easier because it'll all be done on the platform and stored there. But yeah, most companies who foreign qualify are just act as their own registered agent. That does mean you should read the Department of State website and understand what you're supposed to do annually. Like some states are pretty relaxed. New York, you only have to file a report every 2 years and pay a fee, while, like I said, California has an $800 franchise tax every single year. Most people have some form of an annual report or update that you have to file.
Yeah, I think we're actually 49 states. There's one state that is pushing their own digital service.
Oh, who's that?
I forget who it is. And let's see, hiring remote employees outside the US. We are looking at different ways to handle this. There is one company that has been coming up quite a bit called Deal. And I know that Gusto also recently made an acquisition in this area. But the strategy we're seeing those companies take is spinning up co-employers in different foreign jurisdictions. So when you are hiring people or even contracting in those jurisdictions, they are dealing with the taxation and the compliance stuff for you. So if you are going to build a distributed team and you plan to have that as your core team building strategy, I would definitely take a look at one of those services, especially as you scale.
So do you have a list of 3 or 4 PEOs that you like?
We can definitely put one together. I would say Deal and Gusto would be top of mind, but there are definitely others. I think there's one actually called Remote, but we can put one together and send it over to you.
That'd be great. Yeah. So there's Papaya and there's PEO Global, and I don't think Gusto does international, do they?
They just made an acquisition of a company that's in that space. So
Okay.
I believe they will begin offering that shortly.
Cool. Well, I want to make sure that we leave the things open for discussion with people for a second here. Dan, you got any questions? No, Dan?
Oh, he's on mute.
Okay.
Not just yet. I'm pondering.
Yeah. All right. Michael, any thoughts on how you're going to get your shellfish into a C Corp?
The shellfish is a C Corp now. Tom Malone helped me do that with Gust. It's still beyond me a little bit. I got some questions on just the amount of, like, I've probably got 600,000 into the farm now. And when I go to, I'm still looking for a co-founder. How I split those shares or value, right now I got all those shares for what, $64. So
Sounds about right. That means you've left yourself some flexibility though. So if you do find a co-founder or somebody early on, you still have some flexibility there.
Yeah, and I'd say, having a business where you have built quite a bit of value prior to bringing on your co-founder and bringing them on for a specific purpose, there is an existing business here that you have built. So you should factor that in to the equity split, potentially thinking of this person as a later stage co-founder. So instead of being in the neighborhood of 35 to 50%, you may be looking in the neighborhood of low double-digit percentages.
okay, that sort of answers my question. So
Also, from a selfish standpoint, Michael, what's the name of your oyster?
Brave Harbor Oysters. It's Alaska's best shellfish. In the grand plan, there'll be 6 farms, and I just picked up a crabber here last week, so I'll probably start marketing crab.
And you ship to New York, right?
No, Actually just Montana, but
Well, there's
I've got
two guys here
people
from New
all around
York.
the nation.
Yeah, all right, cool.
My girlfriend is a oyster connoisseur, and I'm already checking out the website.
There is.
Shreya, did you get your questions answered?
Yes. Thank you so much. It was really helpful.
All right, good. Karma, how about you?
Did we ever get Karma's audio?
Yeah, I don't think Carmen's audio is working.
Yeah. How about Andrew?
Hey, I'm that MIC co-founder that Treya was mentioning. Hey, you mentioned a couple things about like making sure that you paper all of those like initial cash investments that you're putting into your company. I guess, do you have any recommendations for like, I guess, tools or software for the bookkeeping piece, or like what are there any like standard like documents that you should be making sure that you fill out to properly account for that?
Yeah, you can, eventually you're going to want to get a bookkeeper as more value goes into the business to be sure that they're coding them correctly. You can save yourself a lot of time and future hassle if you just keep good books up until then, which is recording the transactions to who from where, if you buy anything with it, make sure you have a corporate bank account and you're really keeping track of this. I know if you use us and you get with Brex is actually moving in towards kind of supplying a bookkeeping-ish replacement, so you don't even have to go after QuickBooks or whatnot, and you can marry an accountant or a bookkeeper to that eventually. And we do have a partner that we recommend all the time called GBS Tax. They have low-cost startup-oriented bookkeeping. They can do end-of-year cleanup for a really reasonable amount, and they're pretty great.
Yeah, I think generally getting something where all of your spend is going through a single card or a single set of cards into a single account is the best thing that you can do early on to just avoid all of the expense reporting that you'll have to do if you're spending and then trying to bring that back into the company. And I can follow up with John. We do have some templates for just a very simple grid note is what we call it. And basically it's an agreement that sets out an initial amount, and then you can continue to add money over time as you put more money into the company.
Quick follow-up on that. So how do we account for the expenses that we paid with our personal like cards and accounts before the incorporation?
So you can transfer those in onto something like a grid note, and you'll essentially, you can also look at those as like expenses. So typically founders will use a tool like Expensify to just capture receipts and things like that that they've spent on personally, and then expense those to the company.
Hey guys, I have one question, particularly on registered agents, state registrations, and bank accounts. So as I mentioned earlier, we have a Canadian incorporation. And one of the main issues with us is moving money between Canada and the US. So we're trying to open a TD bank account. We have a TD bank account in Canada. We're trying to open a TD US account. And TD US has several different stipulations. One is that you have to be within 50 miles of a TD branch in order to open an account. There are no TD banks on the West Coast. We're based out of Portland, Oregon, where we were initially. So we're considering potentially moving our headquarters to New York in order to open that bank account so we get US investment in and move it. It's pretty complicated, but would you guys, I don't even know the question here anymore, but basically, would we have to incorporate would we have to register an agent in New York in order to open a bank account there, or could you just open a branch there?
So are you asking the question of what bank should I be using that would let me have dual currency so that I could transfer between currency accounts in the same bank that has both US and Canadian offices?
That's the question I had, John. Thank you.
Very interesting. Well, I guess, so first, if you go down the path that you're contemplating here and you do move headquarters to New York, then yes, you will likely need to foreign register there. especially if you're going to open a brick and mortar or an account at a brick and mortar bank. When you foreign register or foreign qualify, you will have the option of just being your own registered agent in the state, using whatever headquarters address or personal address that you have in the state. That will put you in charge of keeping up with basically the bi-yearly filing requirements. You could also pay somebody to act as your registered agent in New York State. And often that will come with them kind of pestering you about those filings, pulling the information from you and making them on your behalf. Then the other question would be, there may very well be one of the neobanks that facilitates different currency transactions. So we can follow up with our partners at Brex. Okay.
Revolut seems to support multiple currencies.
I've actually heard a positive experience with that.
I wonder, in the state of Washington, you have to file annual filings with the state and keep up on that every year. But in Idaho, you file once and you're done. There's no annual filing. You just have to tell them when you start, tell them when you stop, and away you go. And there's no annual filing fee. And so that generates no K1s because you're not spending money, right? So are there any places around New York that are not in New York that don't have annual filing fees like Idaho?
But the nice thing about New York is it's pretty cheap as far as I remember. I think it's $9 biannually, which is not nearly as rough as some other ones.
Sure be nice to prepay for 20 years and just not ever have a transaction, right? We are trying to twist our agreement. So we do the investment from our LLC, and there are no financial transactions. There's no bank account. So there's nothing that produces a report, right?
Yeah, I actually know more of the ones that are a real pain. Like Virginia's $2,700 to get set up for and qualify, which is just ridiculous. And like I said, California is expensive and has annual filing fees. We actually have a couple customers.
Let me ask you to do a blog where you rate the states on the cost of their formation costs.
Yeah, BuzzFeed style.
Yes, the first listicle we'll ever have on our blog.
Well, I use the CB Insights 20 Reasons Why Startups Fail all the time. It would be very useful to have a similar infographic for the 50 places in the stack ranking of why you should pick one over another, right?
Yeah, we can pit the states against each other and try to get them like, oh, we're moved up. We'll put the up and down every year. Like moved up 2 places, moved down 1.
Yeah, I think there's you have a marketing problem around what Gust is, because Gust launch fits into Gust in a way that people don't distinguish.
Yep.
And so you have to figure out how to be equivalent to Stripe in their marketing. So
yeah, we didn't actually do like you were asking before, we didn't open up to international until earlier this year. So we're still trying to get the marketing engine geared up.
So are you coming to Slush?
I probably not, but that is actually a great idea.
Should be thinking about it.
Yeah.
At least sign up and buy a ticket and do the matchmaking
Virtual.
with everyone.
Yeah, do they have a virtual component at all?
The matchmaking is active right now, although I just got a note that says they're sold out. So you may have to finagle your way in from the side.
Knowing David, we could probably get some kind of invite there.
I'm sure you could. Yes, I'm sure you could.
And then, guys, one more question about one thing I've heard of is like fully remote companies actually changing their headquarters every 6 or 8 months, like less than a year, so they actually don't exist in a state for longer than a year.
It's a pain in the tuchus and not worth the effort.
Yeah.
Yeah, I think generally what you would find is that you will pay more in the movement costs and registration costs than you would in the yearly upkeep costs. I mean, your tax preparation alone is going to be a nightmare.
The folks in Idaho, both Loon Creek and Signal Rock, both tout the one filing fee and done kind of thing in Idaho. So it's a sales point that's going on there. I assume Idaho and Nevada have these, simple rules for don't bother me about business thing that are useful. It sounds like it would be fruitful from a digital communications footprint point of view. Any last questions from anyone about things? Well, thank you so much for doing this. I have a bunch more questions about equity and how you manage it. And fortunately, we have a talk on the 11th where we will dive into, splitting the founder's pie and everything with our same two speakers. And so if you want to learn more about what exactly you need to do with equity, we will talk more on the 11th of November.